Let's say you have two property owners not married to each other, and both are deceased. The property's been foreclosed on. What happens to the surplus funds if there are any? That's the question that came up in an asset recovery group I'm a part of. I thought it was a good chance to break down what would happen. The first rule is that a decedent, that is, a deceased individual, cannot sue or be sued, and therefore the deceased individual cannot claim the surplus funds. And if the decedent can't make a claim for the surplus funds, can those funds still be claimed? And the answer is yes. They can be claimed by the decedent's estate. So if you have two property owners not married to each other and both are deceased, you've got two deceased owners, so you would need two separate estates. Each of the decedents needs their own estate. And each estate gets its own executor or administrator, which is the person who is appointed by the court or named under a will to manage the estate. And that is rule number 2. The executor or executrix, or administrator or administratrix, those are the male and female versions of those titles, of the decedent's estate, is appointed by the court to act on behalf of the estate, not on behalf of their own individual self. So the executor or administrator, or executrix or administratrix, can make a claim for the surplus funds on behalf of the estate. It doesn't go to the executor or administrator individually, it goes to the estate. And then, as with all other assets of the estate, net of the estate's liabilities, it gets distributed in accordance with the will, if there's a valid will. If there's no valid will, you would check for the state's intestacy laws for how those proceeds would be distributed.